My name's Samantha Davies. I'm a solicitor at Banalec and Bishop, and I'm here to talk to you about informal lease extensions and the dangers of these. Put simply, an informal lease extension is one that is privately agreed with your freeholder outside of the statutory provisions. A brief summary of the description between the two lease extensions that you may get are as follows. Under a statutory lease extension, then you will get an additional 90 years on top of your unexpired term, and your ground rent will go down to a peppercorn, which is nothing, for the remainder of the lease term. The legislation also provides that if your lease is potentially defective or requires modification to bring it in line with modern standards, so for example with the insurance provisions, then this can be modified in the lease extension and dealt with in one, which is sensible. Under a private regime, there are no such restraints. A freeholder can ask for anything they want to, and so they may seek to include terms which may be onerous to you or may put you in a more disadvantageous position than you're currently in. It may initially appear simpler and cheaper to obtain an informal lease extension by agreement with your freeholder. However, there are some significant risks and pitfalls of doing this. The freeholder may withdraw at any time, and it is a potentially risky strategy if your lease is running down to the 80-year mark. Your landlord or your freeholder can withdraw from the process of an informal lease extension at any time. There is nothing to bind them to continue with the process, and it is only once the document is completed and so signed by yourself and your freeholder that that lease extension actually takes place. At any time before this, your freeholder can walk away, and you have no comeback against them for doing so. There are some risks in pursuing an informal lease extension if your lease is approaching the 80-year unexpired mark. Once a lease drops below 80 years, then the premium payable to your freeholder is likely to rise sharply and continue to rise the shorter the lease becomes. At the time your lease is over 80 years unexpired, you do not have this additional element to pay by way of marriage value to your freeholder. Some unscrupulous freeholders will agree to an informal lease extension if your lease is approaching the 80-year mark. They may drag their heels and be very slow in responding to you, so that your lease then drops down below the 80-year mark, at which point they may withdraw their consent to an informal lease extension. Once this occurs, you will then be left with a lease that is below 80 years, and so will have to pay that additional premium or payment to the freeholder. A potential pitfall under the informal or private lease extension route is that you cannot fix the valuation date. And so if the freeholder decides to take 6 months in negotiations and walk away, you are then left with calculating the lease extension at today's date rather than when you started negotiations. By contrast, serving a notice under the statutory regime fixes the valuation date and ensures your right to a lease extension regardless of how long your freeholder drags out negotiations. When negotiating an informal or a private lease extension, there are no real limits on the terms that can be agreed between the parties. As long as the terms are obviously legal and acceptable by both parties, then the terms will feature in the new lease. At the outset, it may appear that an informal lease extension is cheaper, and for some leaseholders it often does work out to be so. With an informal lease extension, you will have your own legal costs, but you will also be responsible for the freeholder's legal and valuation costs, as well as the final premium that you end up paying. The danger is that if the freeholder walks away at any time during the transaction, you are obliged to pay his costs from the outset, and so you will have to pay not only your own legal costs, but the freeholders, and if you have no lease extension at the end of that, you will still need to follow the statutory regime in order to obtain a lease extension, effectively incurring wasted and duplicated costs. There is nothing to stop you making an informal approach to your freeholder. It's not going to prejudice your position in the long run or prevent you from serving a statutory notice should negotiations with your freeholder fail to materialise in a lease extension. It's important to appreciate that any informal approach does not guarantee a lease extension, and so your freeholder can walk away at any time. However, that said, many private negotiations do complete and result in full lease extensions. The pitfall and the danger is that your freeholder may stall and may walk away from the process, and if this is, say, 6 months down the line, your lease is that little bit shorter, and so this may affect the premium that you end up paying to your freeholder ultimately by following the statutory route.